Hi, I'm Carl Pearson, and this is a timely topic since qualified immunity seems to be discussed all over the various press participants. And I've entitled it Exception to the Qualified Immunity for Police. My name is Carl Pearson, and as a former civil rights attorney who has sued federal and state prosecutors, I'm quite familiar with the doctrine of qualified immunity. The issue is so important today that the U.S. Supreme Court just ruled on the issue by refusing to hear a case in which qualified immunity was upheld, as usual, by the lower courts. It takes 4 justices to permit an appeal to be heard in the U.S. Supreme Court, but only 2 justices voted to hear the appeal, the most conservative and one of the most liberal. National Public Radio had a story with the headline which reads, quote, "Supreme Court will not re-examine doctrine that shields police in misconduct suits," unquote. The NPR story is worth reading, and its URL with others is in my description for this video. First of all, the immunity doctrine was created in judicial decisions and not by the Constitution, so that any change in the judicial doctrine can be made by federal or state statute or even by appropriately adopted rules at a lower level. Wikipedia states, quote, "Absolute immunity is a type of sovereign immunity for government officials that confers complete immunity from criminal prosecution and civil suits for damages as long as officials are acting within the scope of their duties," unquote. During the past several years, the absolute immunity doctrine has been claimed by President Trump for activities that occurred prior to Trump's inauguration, and it is unclear today how much additional absolute immunity is to be given to a sitting president. Now, let's look at the doctrine of qualified immunity. It is often sought in defamation lawsuits, but only applied when a defamatory statement of fact is made in a filed complaint or other filed document to ensure that there is no libel action for filing a true statement. However, if a copy of the complaint is handed out to the press or mailed to friends, for example, there is no qualified immunity. The same situation exists with statements made on the floor of Congress. And by the way, let me go back. When I said there's no qualified immunity, it's for the person who mails that complaint. It isn't necessarily the plaintiff who mailed it. So whoever mails a complaint, even if it's the plaintiff or someone else, there is no qualified immunity there. The same situation exists with statements made on the floor of Congress. They're granted qualified immunity to encourage statements to be made without concern for the laws of libel in the pursuit of the congressional activities. But if the same statement of fact is made by one of the elected officials at a political rally, for example, his qualified immunity is lost. Here are other instances where absolute immunity is provided. Judges acting in their judicial capacity, government prosecutors while making charging decisions, that is, what charges to put within a criminal complaint or indictment, executive officers while performing adjudicative functions, close presidential aides requiring absolute immunity, and witnesses while testifying in court, although they are still subject to perjury, which is seldom ever seen as an action against any witness. The purpose of the qualified immunity for police and prosecutors is the same, to encourage them to do their respective duties without fear of criminal or civil lawsuits. But there are exceptions, which is why the immunity is qualified. Let's look at the qualifications. Wikipedia states, qualified immunity is a legal doctrine in the United States federal law that shields government officials from being sued for discretionary actions performed within their official capacity unless their actions violated, quote, clearly established, unquote, federal laws or constitutional rights. Another definition is provided by a law firm, the Sanders Firm, PC. Quote, qualified immunity is granted to local, state, or federal employees who, while engaged in discretionary functions for the government, performed actions that did not violate, quote, clearly established law, unquote. Employees are still immune even if later their actions are discovered to be illegal, end of quote. What this means is that while police are handling a demonstration, riot, or a driver asleep in a Wendy's drive-in line, so far something within their official capacity, they are not allowed to violate, quote, clearly established, unquote, law or constitutional rights. There are two ways for the police officer to lose his or her qualified immunity. The first is to establish that the police officer was not performing the discretionary action within his or her official capacity. I would look to see what written or verbal policy, rules, or instructions had been violated, if any, to try to establish that the action in question was not permitted and therefore the police officer was not acting within his or her official capacity. This is why there are numerous jurisdictions enacting rules right now prohibiting chokeholds or prohibiting use of deadly weapons in prescribed situations. Violations of such policy, rules, or instructions would enable a prosecutor to argue that the police officer, as to the act in question, was not acting in an official capacity, period. The second way to lose the qualified immunity is to violate clearly established law or constitutional rights. A lot of case law has been created in which judges have given abusive police officers a pass by distinguishing prior case precedent so that there was no clearly established case law to hold against the police officer. As the NPR report explains, quote, because of recent Supreme Court decisions, lower courts have most often dismissed police misconduct lawsuits on grounds that there is no prior court decision with nearly identical facts. I'm going on with a quote. Several recent studies, including one conducted by Reuters, have found that dozens of cases involving horrific acts, some just as bad as those involving George Floyd in Minneapolis and Breonna Taylor in Louisville, Kentucky, were thrown out of court on the grounds that there was no, quote, clearly established, unquote, court precedent forbidding the conduct. Now, that's end of quote. A typical decision of the court says something like this, quote, on appeal, the Second Circuit held that the individual police officers were entitled to qualified immunity from plaintiff's Section 1983 claims because her right to act as healthcare agent outside of a hospital setting had not been clearly established at the time of the incident, even though it was established subsequently. The present effort in many cities and towns throughout the nation is to adopt specific rules to limit police abuse and killings. These explicit rules are needed for a state or federal prosecutor to show that A, the police officer was not acting in an official capacity as to those acts, and or B, the police officer's conduct violated clearly established law. With these rules, the unchecked activities of errant police officers will be substantially reduced by a real threat of imprisonment, and for those errant police officers who are slow to learn, they are more apt to wind up in prison with no job and no pension. Well, I've said what I wanted to say, and I'll be back soon with my next video.